to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all.
I hereby announce that this meeting is being held in accordance with Chapter 231 of the Open Public Meeting Act. Proper notice of meeting dates has been given to the Morris Newsfeed and the Morris County Daily Record and posted on the bulletin board in the Borough Hall. This meeting is a judicial proceeding. Any questions or comments must be limited to issues that are relevant to what the board may legally consider in reaching a decision, and decorum appropriate to a judicial hearing must be maintained at all times. Karen, roll call, please.
Mr. Orpington?
Present.
Mr. Wolf? Mr. Bezel?
Here.
Ms. McCluskey? Ms. Stecker? Present. Mr. Travaglia?
Present.
Mr. Houston?
Here.
Mayor Carr?
Present.
And Mrs. McCluskey?
Okay, the first item on tonight's agenda is the approval of meeting minutes for the October 20th, 2025 meeting. The board has received copies of those minutes. Does anybody have any adds or changes?
On the bottom of 398 and the top of 399, the last sentence is a read.
Oh, okay.
Yep.
Thank you.
You're welcome.
That was easy.
Anybody else? Okay, with that correction, can I get a motion to approve these minutes?
So moved.
Is there a second?
Second?
Okay, all in favor?
Aye.
And may I ask you questions first? Okay, thank you.
Okay, motion carried. Okay, next on the agenda are comments from the public, and this is specifically for items not on tonight's agenda.
Hello.
My name is Carolyn Bennett, 19 Dayton Road. I just have one thing to read. I don't think I'm breaking any rules. And my kids are here, so they might run out, but hopefully we get through this. Okay. Good evening, everyone. I hope you're all doing well. Although I haven't been at this forum in a while, it's been nice to see many of you guys around town and at other meetings. And my children here tonight because, you know, the ordinance questions that I have and have been discussed, they affect their daily lives as well as some of the other families on Dayton Road. So first, I wanted to thank the Borough Council for all of the work that they've been doing on amending the ordinance that allows drive-thru restaurants in residential zones. At the November 13th meeting, the Borough Council unanimously voted to revise Ordinance 14-2023. Ironically enough, I was delivering those twins when the certified letter went out announcing that the drive-thru was going to be added as a permitted use, buried among other updates. So I'm especially glad to see that 2 years and 1 month later, the concerns that residents have been raising are finally being acknowledged, and the drive-thru allowance is, being discussed to being removed. Anyways, as written, I know we all know what the ordinance says, but this drive-thru restaurant, the ordinance allowed drive-thru restaurants in the heart of downtown Morris Plains without clear guardrails related to safety, pedestrian access, environmental impact, or traffic flow. The McDonald's project highlighted many of these concerns. So this new ordinance, Ordinance 11-2025, will remove drive-thru restaurants as a permitted use in the borough's B2 zone. And while this isn't going to change the McDonald's project currently approved back in December 2024, it will prevent future drive-thru restaurants in the B2 zone, which is crucial to residents' safety who live there, crucial to those 3 little ones back in that row, and like I said, many other residents in the area. So while we have nothing against McDonald's, although it's not necessarily at the top of our takeout list, the drive-thru location proposed for the 413 and 435 Speedwell Avenue is just not the right business model for that area. So I'm looking forward to the next steps, because I know you guys are gonna be continuing discussing that at upcoming meetings. Now, my second point, I do mention those speed well addresses because it connects directly to some of the questions I've been trying to wrap my head around lately. And I raised this at last week's council meeting, and I appreciate that the mayor, you committed to helping me find an answer. I can send you my email so that we can connect over email. But I know, Bill, you were there, Sue, I think I saw you in the crowd too. But I wanted to bring this question to this board because ultimately the planning board is to approve the McDonald's application. So I assume that the answer is known here. When I look at the borough's code, specifically Article 5, Chapter 22, I interpret the weight restriction ordinances as follows. Trucks over 4 tons are not permitted on Dayton, Academy, Canfield, Mountain Way, Sylvan Drive, Trow Ridge, or Washington. Trucks over 5 tons are not permitted on Malapartis. Deliveries are exempt only when the delivery is to an address on those streets. So that's where my confusion clicks in, and my major issue with this. The McDonald's project address is not on Dayton. It's on a Speedwell Avenue, the addresses I just mentioned. But this application was approved with an egress onto Dayton Road. So that means large delivery trucks, semi-trucks carrying food, supplies, waste removal, all of that is gonna be using Dayton Road, even though it falls on that weight-restricted residential street, and McDonald's is not on a Dayton Road address. The applicant never requested a variance for this, but if I am wrong, I am looking forward to being proven wrong by reading testimony or timestamps of videos or where they did request that. Perhaps this is exactly the scenario that the ordinance seemed designed to prevent. Many residents flagged this, yet the conflict with the ordinance was repeatedly downplayed in the countless hours of discussion that a lot of people were involved in. I don't know how many of you guys still have the McDonald's application on top of your minds, but for us living right there, we do. I invite you to walk by the current state of the site, piles of debris flowing everywhere. You will have to turn onto Dayton because they have a nice green cover for anyone driving on Speedwell, but if you come down onto Dayton, that cover is gone. So you can see right into the site, you can see everything that's there. I personally don't see how it's any less of an eyesore than the Friendly's building that was there, which people had made a point of, we gotta get it down, it's an eyesore. But to each their own. So we also learned recently that Ordinance 6/2025 added 2 more streets to those truck restricted roads, Rosedale and Hillview. And there is signage that needs to be ordered, or DOT has to approve it. Whatever the process is, there has to be signs put on those 2 new streets, which also leads to signs being put on the other streets that I previously mentioned that has not been there. So it just leads to a lot of questions in my head, like, did the McDonald's application get approved without addressing this variance simply because there was no sign that said trucks over 4 tons are not permitted? I hope that's not the case. So I'm not looking for an immediate answer tonight, and I don't know how much longer they're gonna be quiet for. So I just respectfully request clear clarification on all of this, whether it's a phone call, an email, a written letter to my house that I will keep my eye out for. I am happy to talk in a one-on-one setting, but I don't have clarity on, maybe I'm interpreting the ordinance wrong, the weight restriction, how it relates to the McDonald's application, and how the McDonald's application got approved without requesting a variance for that ordinance. I know that the mayor's going to be looking into it, like I said, I appreciate that, but also maybe some of the other yes votes can chime in, because I'm assuming we all needed to, you know, understand that before we voted.
Yeah, so that's already in the works, and when I get all of that, I will make sure to get in touch with you on the testimony that was brought up at McDonald's, and so that's already in the works.
Okay, like by end of month, do you think, or like in 6 months? Or-
No, I mean, relatively shortly here, sure, go ahead, Mr. Chairman.
Andy Brewer, attorney, I was at the meetings. The reason, when the application comes in, it is reviewed, the applicant says we can create X, Y, and Z variances. Planner, our planner, our engineer also look at it and say, yes, you need those variances or not. No one flagged that as a variance. I think, and number one, it would be a variance, because of a technical aspect, the prohibition on using that road is not in the zoning ordinance, it's in the general police powers. This board can't give a variance from that. They can prohibit something that's illegal, but they couldn't give a variance. That's one. But that presumes that the interpretation is as you read. The applicant, our engineer, the board's engineers, and people that read it this way. Not that, that the limitation is to deliveries with a mailing address on a particular street, but deliveries on, and to that on that street, not a mailing address on that street. McDonald's is most definitely, the property is along that street. It doesn't say to a place with a mailing address. However, be that as it may, that was raised at one point by members of the public, absolutely. The planner, even the planner, Mr. Steck, who came on and spoke on behalf of the objectors and the public, downplayed that issue. That still doesn't answer the question. It's an interpretation that almost everyone said it was not the exception for, again, a street address, but a delivery on that street. Not to, it doesn't matter what the post office calls it. Be that as it may, this matters on appeal. And it is currently scheduled for a trial, which is really oral argument. Both sides submit briefs, say this was valid or wasn't valid. But I think January 8th or 9th. So the judge is going to decide by that. So if you are right, and your interpretation.
Sorry, if I'm right, or are you saying I am right?
No, if your argument is right on the interpretation, the judge will agree with that. Judge Mankiewicz is a very bright guy. Been before many times. If in fact that's agreed, there would be a reason to overturn what was done. If he doesn't agree with you, there's lots of other reasons to challenge. But that issue is going to be addressed by the judge. That interpretation, whether or not that's valid.
Okay, so, I don't know if this is, I thought it was very black and white, like, street address
But
is where delivery is being made.
It doesn't say add, that's the point. It's for delivery on that street, it doesn't say with a postal address on a specific, and I don't, we have to go back and forth.
No, I know,
But that's the difference.
that wasn't,
That's the difference.
my full question was gonna be, would it be worth, and this is a question maybe rhetorical, to further define that clarity in whatever that, the police code, the ordinance, like, do we need to get to that level of granularity so this doesn't happen in the future where it's, oh, well, when we say address, do we mean this side of the property or the mailing address where the mailbox is? Like, do people usually get into that level of detail, or is it usually up for interpretation?
I think that's up for interpretation, but I think more of, I think it's, and again, my understanding, and most of the professionals who looked at it, that it was just a gut thing, because you ride them on a particular street and you deliver it to there or there or there. It doesn't matter. And again, I know this interpretation is different to you, I'm not saying it has to be, but the thought process is, you don't want it on that road unless they're gonna deliver something that's on the road, not with the mail address on the road, but with where a truck can get on or off using that road. And that's the thought. So I think that hasn't been an issue because it's been interpreted generally the way it was looked at here, not with a particular area of the mailing address. But if the public, which is your voting public and you vote for people in the governing body, believes that should be changed, absolutely. But the understanding of it up to this point is no, is a different understanding. Not that it can't be, that you're allowed to, as the public, vote for officials and say, we think you should change your ordinance to be X and Y, but it hasn't been interpreted that way.
Okay, so everything that you did just voice over though, you're confident that it was brought up and proven such way in the testimony that's on record?
Oh, no, but you don't, when you, the question is how a law applies or what it means, you don't have testimony about that, that's a legal question. Do they need a variance or not? And it was discussed, and that issue was discussed. As I said, I remember it because the planner that spoke on behalf of the objectors, who objected to the application, when he was asked for it, said, it doesn't really, that doesn't apply. I'm paraphrasing, but even Mr. Steck was not of the opinion that would prohibit the use of the vehicles that were going to make deliveries to McDonald's and then exit out. He wasn't given that much play. He had lots of other problems with the application, but not that one.
So Mr. Steck was, I don't want to be grouped as a part of the objector because I
Understood.
actually never even spoke with the man. I saw him at a meeting similar to you. There were other planners though involved in that interpretation because you only mentioned his name, but to my understanding, there were other planners, right?
Other planners, but when it was raised, the discussion that I gave you on how it would be interpreted was given as the reason why a variance is not required. And anybody could have said, no, it should be interpreted that way, but that's, that was generally understood. And so that's how it came about. There's not testimony on what did the governing body mean when they said property and didn't say street address. No, it was not that. There was a question, does it apply or not? Would it prohibit these trucks? And the understanding, which was stated in the way that I said, is generally accepted by the professionals that looked at it. It's an interpretation of the statute. It's not there for facts. People say, no, this is it. It's not that way. People can read it, and the professionals read it, and the determination was the advice that was given by the planners. My interpretation is the same, but again, I said, this is going to be before Judge Minkowitz on the second week of January. This question will be decided.
Okay, yeah, I mean, I need to digest all of this. I don't want to just say that this has answered all my questions. It takes me a little bit of time to listen to everything that you just said, but it's still not sitting right with me, and I feel like one planner's name has been thrown out, but I would like to hope everyone's best interest is the safety of everyone, and if there is a police law saying really heavy trucks shouldn't be on this road because little kids and residents live here, then I just can't wrap my head around why we would be like, yeah, let's approve an application that literally forces these trucks on said road, because the egress is only on that road. Like, I would be just interested in maybe continuing this discussion in a smaller form if so fit, but I think I have some follow-up questions, and yeah, I'm looking forward, I guess, to January. Thank you. I know that was longer than maybe a time limit, but I appreciate it.
It's okay, Ms. Bennett, thank you for voicing your concerns. I do just wanted to your concern about whether it looks at the street address specifically or just the street itself, as Mr. Brewer was saying, right? It doesn't specifically call out postal addresses in the ordinance. That's something for not the board, but for the council to look at, right, as the ordinances. So, and I hear your concern, and I think it is something worth looking at. We do need to, currently, the ordinance is being looked at by NJDOT. We actually got some response from them. There's some action that we have to take on our side to comply with what they've asked us for in order to get the signs. But it's also something we can look into as to whether or not we can say delivery to postal address, for example, right? I know right now it's very generic. It says on the street, but it's something that as the council liaison to the ordinance committee, we can look into that.
Okay.
Okay.
Sounds good. Okay, I'm going to respectfully, at least, as to not disrupt the rest of the meeting, but I will be watching because I do watch you guys, and I am glad when we do the right thing. So, thank you.
Ms. Bennett, thank you. Anyone else? Okay, close this portion of the agenda. Committee reports, minor site plan committee update. None. Master Plan Review Committee, any updates? Karen, correspondence and bills?
No, oh, it's bills.
Yeah,
and
the
bills.
bills.
And no
Good.
correspondence.
So, purchase order 202-52093 for Marizini Falcon LLP, McDonalds litigation, $14,172.04. Purchase order 202-52089, again, Marizini Falcon LLP, general legal services, $1,102.50. And last is 202-52036 Anderson and Denzler. Engineering services, $290.10. That's all the bills. And I will approve these. Will anyone else please give me a second?
Mr. Hardwick, just real quick, that first one you read, that was, did I get the number correct? $14,172.04, is that correct?
That's correct.
I will second. Sorry?
Force, you're right.
Okay, I will second them as you read.
Okay, Karen, roll call, please.
Mr. Oglesworth,
Yes.
Mr. Bezel,
Yes.
Mrs. Stecker,
Yes.
Mr. Pravaglia,
Yes.
Mr. Houston,
Yes.
Mayor Carr,
Yes.
and Mrs. McCluskey.
Yes.
Okay, next item on our agenda is under applications. We have PB-1-25, which is Rivian LLC, 329 Speedwell Avenue, Block 23, Lot 1.01. Tonight, the board will review the application for completeness only, and no testimony will be heard. Mr. Paro.
Thank you very
Welcome.
much. I appreciate it. Again, Joe Caparo from Porzio, Bromberg, and Newman on behalf of Rivian. As noted, we are here for completeness. As the board may recall, we were here at the October 20th completeness hearing. Based on the recommendations of your consultants, the board granted some of the checklist submission waivers. Two were not granted, those were denied, and we agreed to resubmit and include the refuse and recycling plan and a full landscaping plan. Resubmission was made to the board and to your consultants, and we did receive responses from the board engineer, an updated review letter dated November 12, 2025, and your planner issued a report dated November 13, 2025. Both of those letters recommend administrative completeness now that those two missing items have been supplied. So we are here just for confirmation that the application is now technically complete, and we respectfully request that it be placed on the board's agenda for the public hearing at your next meeting. That would give us sufficient time to get our public notice in order. Happy to answer any questions. I believe the professionals have reviewed those materials.
Yeah, so Mr. Ryden, on your, the board's received your documentation. That was the 11-12 memo.
Correct.
You want to take us through that real quick?
Well, it's pretty straightforward.
Yeah.
Exactly what the gentleman said, the waivers were granted, the outstanding information was provided, and I found the application to be complete, administratively. That's
And
the long and short of it.
yeah, and Ms. Laney's not here tonight. I guess Kate, I'm not sure if Kate called. I know she's supposed to be here, but same is true with Liz's report.
As I read her letter, yes.
Correct. So with the recommendation of the board, with the recommendation from our engineering and planning professionals, can I have a motion to deem the application complete?
So moved.
Is there a second?
Second.
Karen, roll call.
Okay, I just want, it was Mrs. McCluskey and Mrs. Stecker, right? Okay. Mr. Oglesworth,
Yes.
Mr. Bezel,
Yes.
Mrs. Stecker,
Yes.
Mr. Pravaglia,
Yes.
Mr. Houston,
Yes.
Mayor Carr,
Yes.
and Mrs. McCluskey.
Yes.
And so the December meeting is in 3 weeks. It's a week earlier than normal, so it's on December 8th.
December 8th. Okay, we'll see you then. And if there's anything else, Karen, that you need to answer that, just let me know.
Yes, okay.
Great. Thank you so much.
Excellent. Thank you.
Appreciate it. Look forward to seeing you on December 8th.
Okay, next on the agenda, old business, anything? on this? Any new business?
I do have one thing for new business. Just as the board heard earlier from Ms. Bennett, on Thursday night, the council unanimously passed the ordinance that would effectively remove the drive-through restaurants from the B2 zone.
Introduce the ordinance.
We introduced the ordinance that would remove the drive-through restaurants from the B2 zone. The next step is for the planning board to review, to make sure that it is not inconsistent with the master plan. So that'll be coming to the planning board. at the next meeting, and that's where the discussion will be. And, you know, based upon the recommendation from the planning board, the council will look to take hopefully final action at the next December council meeting. So just making you all aware that that's coming up. All right?
And that information on the ordinance is in one of the packages that you'll pick up on the way out tonight. Okay?
Does the board want to, let Ms. Laney weigh in on that by the next meeting?
Yes, yes.
A copy is for Miss, I have a copy for Miss Lady also.
And I'll reach out to her. I'll make sure
And
she's,
Mr. Brewer, sure.
I'll make sure she gets this next meeting. Okay. All right, first I want to wish all the board members and everyone in our public audience a very happy Thanksgiving. So I hope each of you are able to spend time with your families. Next scheduled planning board meeting is December 8th, as previously mentioned. It's right here in the council chambers. Can I get a motion to adjourn tonight's meeting? Steve, second, Mr. Cook. Okay, Mayor Carr, all in favor? Aye. Opposed?